Appearances, please.
Joanna Terry for the people.
Patrick Craig on behalf of the defendant.
Thank you very much. The defendant here is seated next to counsel. We had a pretrial conference earlier. That was conducted in chambers. Counsel informed me that there would be a pretrial agreement today. Counsel, tell me what it is.
Thank you. It's my understanding the defendant is guilty to.
I think it's a no contest. Is that right?
That's correct. No
Yep.
contest. Attempted count one.
Yep. So we have count two, which is the domestic violence. He's pleading no contest to that.
That
He's pleading no contest to an added count three, which is an attempt to strangulation or assault with intent to do great bodily harm. Less than
Yes.
murder. And then in exchange for that, the count one will be dismissed.
correct. And then will the attempted strangulation will be on a delay of sentence.
Oh, I missed that part. Is that correct, Ms. Jerry?
It is, and there's restitution of $332.13 to Carly Grogan for a windshield.
All right, I've got that. Oh, that's on here. Thank you. I did not see that. And see that there. Comment. Oh, wait. I couldn't really read the writing very well, but I now can interpret what it says. Thank you. All right.
We
So
don't use ink anymore. So.
it's okay. No, that's all right. You should see my kids try to write a letter. All right. I definitely don't know how to address an envelope. So, Mr. Mitchell, is that a correct and accurate statement?
Yes, Your Honor.
And have you, Ms. Carey, have you gone over this with the victim in the file?
My understanding that Mr. Carnes did, yes.
Okay, thank you. Is the victim in this file here today? Thank you. All right, Mr. Mitchell, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Sir, you may lower your hand. Back on. September 15th and 16th of last year, 2025, were you on probation, parole, or bond?
Yes, Your Honor. I have probation.
And has there been a probation violation taken?
Yes, Your Honor.
Did I do it?
That's resolved, Your Honor.
As long as it's resolved.
Yeah.
All right, thank you. All right, Mr. Mitchell, you are currently charged on the felony information with 2 counts. Count 1 is assault with intent to do great bodily harm, less than murder, or by strangulation. That is a felony punishable by up to 10 years and or up to $5,000. Count 2 is aggravated domestic violence. That is a misdemeanor punishable by up to 1 year and or up to $1,000. Now I'm told you're going to plead no contest to that count 2. Again, that's the aggravated domestic violence. Count 1 will be dismissed, and then you'll be pleading no contest to an added count 3. That added count 3 would be an attempted version of count 1. Therefore, we call it an attempted strangulation. That is a felony punishable by up to 5 years and or up to $2,500. There's some other terms and conditions here that apply. Now, first of all, if I said the word guilty, I apologize. I know in my head it's a no contest plea. A no contest plea is the same impact as a guilty plea. The difference is instead of requiring the defendant to recite a factual basis, I am going to look at something such as a police report. You understand?
Yes, Your Honor.
Now, what's important here is that you need to know that whatever's in that report, you can't challenge today or when we come back for sentencing. Do you understand?
I do, Your Honor.
All right. Now, I can take a no contest in a couple situations. One is potential civil liability, and I understand, is that the reason for it here today, Mr. Fragel?
Primarily intoxication.
Intoxication? Okay, thank you. That's right. I'm sorry, I do recall there was a lot of consumption that night. All right, so Ms. Carey, do you agree that taking a no contest plea is appropriate? Thank you. All right, so next, by entering the pleas here that I've discussed, there's this other term, a couple terms regarding sentencing. And by the way, I'm going to say that I have this written pretrial agreement, and at the bottom it talks about a sentencing guideline range of 0 to 17. You, Mr. Fragel, go over with you the Michigan sentencing guidelines and what that means?
Yes, Your Honor.
I want you to understand that the sentencing guidelines are not mandatory. Okay? I can go above, well, I can't go below 0 to 17. I can't give you extra days onto your life, which would be a great thing if I could, but they are not mandatory. That's what I need you to know, okay?
Okay.
And it even says on here, it's an estimated guideline range. Now, also, as to that added count 3 of attempted strangulation, there's an agreement that's called the Killebrew agreement. You heard me talk about this with a previous defendant. That means that I'm not a part of it yet. I don't know at all if I'm going to go along with it. I'll let you know next time we come back to court. Now, if I don't go along with it, you have the right to withdraw your plea and come back to this stage of proceedings. Now, what is that Killebrew agreement? The Killebrew agreement is that you would be placed upon a 1-year delay. And even though we put terms and conditions on it, it's like probation, it's not. We call it a delay, and you're gonna have to obey the conditions I put on you. I might put on there, no consumption of alcohol. You test positive, both the delay, and you'll be stuck with the conviction. And if I put a no contact order, I don't know if I'm going to, I'm just giving you examples, and you violate it, withdraw that delay and you're stuck with the 5-year felony. You understand that?
Yes, Your Honor.
All right, good. Now, by entering a plea of no contest, you're not going to have a trial of any kind. And I'm holding up a piece of paper that at the top says advice of rights, has your signature at the bottom. Did you sign this piece of paper?
Yes, Your Honor.
Did you read through these rights before signing?
I did, Your Honor.
And did you understand what you read?
I did, Your Honor.
So do you understand that if you enter this plea of no contest today, and I accept that plea, you'll be forever waiving those rights that you read, reviewed, and signed acknowledgement of forever as they apply to this case?
I do.
Also, you'll be given up the right to claim the plea result of any other promise, threat, or inducement that I haven't been told about. Have there been any other promises, threats, inducements that we haven't talked about yet today?
No, Your Honor.
Therefore, do you still wish to enter the plea?
Yes, Your Honor.
Pay attention. I'm gonna ask you what the pleas are, and I expect them. I'm not telling you what to say. You saw it happen earlier. Even when I warn people, they don't pay attention. I anticipate the words out of your mouth to be no contest. As to count 2 and the added count 3, attempted assault by strangulation. How do you plead?
No contest.
Good job. All right, before I can accept that, I need to have an exhibit. Madam Court Reporter, if you could please give me a sticker on that. Thank you, Nancy. I was provided this exhibit prior to taking the bench. It was given to me in chambers. It is now marked as People's Exhibit number 1. It is a Wexford County Sheriff Incident Report number 83-2501691, and it consists of 2 of what appears to have been originally 5 pages. Ms. Carey, are you asking the court to accept that exhibit?
I am.
Mr. Fragel, any objection?
No objection.
The court again has reviewed this exhibit, and I'm going to state that. 1, it covers the appropriate date. 2, it covers the appropriate jurisdiction. And 3, beginning at the bottom of page 1, continuing on to page 2, there is a description of the events from the alleged victim here, Carly Catherine Grogan, and it describes an event on September 15th carrying into September 16th, where there is heavy intoxication. Now, I also note that there were a couple differences of events. There were some pushings or pushing somebody down to the ground, but then there was a second event that involved the strangulation. Ms. Carey, do you believe that the interest of justice permit the court to accept the no contest plea?
I do.
Mr. Fragel, do you agree?
Yes.
Ms. Carey, do you believe that the contents of this report satisfy a conviction of the 2 counts?
I do.
Mr. Fragel, do you agree?
Yes, I do, Your Honor.
Ms. Carey, are you aware of any other promises, threats, and inducements?
I'm not.
And Mr. Fragel, how about you?
None, Your Honor. No.
All right, thank you. All right, the court agrees, finds that the interests of justice do not require the defendant to recite a factual basis based upon, it could be both civil liability, but also the severe level of intoxication. demonstrated at the time. Intoxication is not a defense for criminal responsibility. Therefore, I find that I find that the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds the information contained in People's Exhibit number 1 satisfies the elements for count 2 and added count 3. Therefore, he's found guilty of those 2 offenses. We'll be back here in about a month for sentencing. That will be typically on a Monday morning between now and then. And agent from the Department of Corrections is going to prepare a pre-sentence investigation report. Such a report must be prepared anytime someone's convicted of a felony in the state court of Michigan. Do we have DNA, or was it taken probably at arrest because of the nature of the charge?
It was already.
Available?
Yeah.
Okay, thank you. There are 3 steps that involve you in the preparation of this report. First, when you leave the courtroom, take the elevator all the way down, or you can use the steps, but I don't know how many I do, but all the way down to the bottom. Do a sharp right-hand turn. At the end of the hallway, you'll see a door. Go through the door. I don't mean to sound like I'm talking about go.
I'm gonna take you down there, Your Honor.
I know where I'm
All right,
going.
good. All right, thank you very much.
we address bond?
Yep, but hold on. 1, go down there, get the packet completed. Number 2, they'll set up an interview with you and Mr. Fragel. Number 3, Mr. Fragel needs to stay in contact with you to tell you when to be back to court and to meet with you and go over the contents of that report. You understand?
Yes, Your Honor.
Thank you. All right, Mr. Fragel?
Yes, Your Honor, the defendant has been on bond since September 15th thereabouts, as well as probation. He's been testing 3 times a day with the handheld device.
Yes.
Since the arrest, he's been working 2 jobs. He enrolled in the men's domestic violence group and is taking this matter seriously. We would ask the court to reduce his testing to 2 times per day. That may give him a little more sleep since he is working numerous hours a week, and he has not had any violations since his release from custody.
Miss.
Thank you. While the court did read the report and knows that there was heavy alcohol consumption during this incident, which turned quite violent, so I would ask the court to keep it where it is.
Thank you. Madam Court Post sent me a note here. I forgot to cover something with that pretrial agreement, so I'm going to reopen the findings. Sir, also there's an agreement that you're going to pay a certain amount of restitution in the file, and that was $332.13. Do you agree?
Yes, Your Honor.
Do you reassert your plea of no contest?
Yes, Your Honor.
The court therefore reasserts its findings of guilt as the 2 counts. Okay. Ms. Carey, could you tell me a little bit about the defendant's prior criminal history, whether or not he has any prior convictions that involve alcohol, such as drinking and driving?
It's possession of marijuana. That's 22 use of marijuana. 2022 attempt retail fraud, 3rd. And then the one he was on bond for, or on probation for, was assault and battery, which was pled from an aggravated assault. I don't know about alcohol, it doesn't say in this.
All right, thank you. Second. Mr. Fragel, did you say he was doing some kind of treatment or rehab?
Yeah, the men's group is focused on domestic violence, family dynamics, including alcohol counseling.
Through where is that?
Through Chase Valinsky. His office is out of Petoskey, but it's a Zoom. It's a weekly Zoom. It's a 39-week program.
All right, thank you. The court will grant.
He does work from 3:45 p.m. to 3:45 a.m.
Well, I'm about ready to say I'm going to grant. Nobody should talk because you might mess it up. The court's going to grant the modification as follows. Pursuant to Court Rule 6.106, I'm allowed to order that a person participate in rehabilitation. So therefore, I add to your bond conditions that you must continue the rehabilitation program with, the name again,
Men's group
men's group from
with Chance Galinsky.
Chance Galinsky. Good luck spelling that. All right. And now here's what you're gonna do. You're gonna go to community corrections, sir, and you're gonna sign a release. That release does not allow community corrections to ask, hey, has he talked to you about potty training? And did anything else go? They're not gonna know anything about your conversation. They're just gonna say, is he still attending? Oh, thank you. That's it. I just need to have some way to make sure that you're doing what I told you to do. Next, the court reduces that you don't have to do daily press testing. I'm just gonna make it random testing upon request by the Department of Corrections.
Okay.
Thank you. So you may go down to community corrections and take care of that as well today when you leave the courtroom. We're done. We're adjourned. Thank you.
Thank you, Your Honor.
And of course, I'm warning you. Don't test positive because I'm giving you a little bit of, right? I'm letting that line out.
I know, and I appreciate it.